Thank you everybody for joining us today. My name is Ben Rhodes, Senior Vice President with CAMS. Happy St. Patrick's Day. I've got my green, so I hope everybody is wearing their green as well. Today's topic, going green. So lots to learn about what it means to go green for your community. As a reminder, we are recording this session and you can see it probably first to next week. We'll have it posted on the camsmgt.com website. If you click on the board member section under webinars, all of our previous sessions have been recorded and posted online. So we have close to 25 different sessions that you can see. We will also be doing questions at the end of the session. So if you want to use the Q&A option, Steve will answer as many questions as he possibly can. We are going to try and keep this to an hour tonight. So we might run over, but the total talking will take about 50 minutes and we'll leave it close to 10, 15 minutes for Q&A. So again, thank you for joining. And Steve, I will turn it over to you.
All right, great. Thank you, Ben. And thank you all for taking your time tonight to learn about the green initiatives. Ironic that we're doing green initiatives on St. Patrick's Day, but I'm gonna go ahead and get started to see kind of who is with us this evening. So I'm gonna launch a poll here with a question. Let's see. Wants me to share results. I haven't done a poll yet. Hold on just a second. All right, well, I'll tell you what, let me go. I think I know what happened. All right, really the question that I have for you all tonight is, what type of association are you in? It kind of gives me a way to answer and maybe get closer to what you guys are wanting to hear tonight if I know where you all are. And so I'm going to launch the poll here. I apologize, I'm having some technical difficulties. Wants me to end the poll. All right, well, I'll tell you what, I'm going to cover all the bases here shortly, so it won't matter. But single family detached home, okay, houses next to each other. A single family attached home is a townhome. Stacked condominiums, those are condominiums that are on top of each other. And then non-stacked condominiums. Believe it or not, condominiums can be side by side and not stacked. And then you have mixed, some have single family with condominiums, with townhomes. And so I'll touch on each one of those as we go along here. And get you your answers for the area that you guys are in. Green initiatives. The big one really is solar panels. Obviously, that's what everybody is currently dealing with for the most part. And what is the law in North Carolina and South Carolina on solar panels? But before we get into that, and we're going to have a lot of examples. I got some really interesting cases that are pending before the Supreme Court of North Carolina on that, and some kind of local case that came up where one of my association clients got sued over some solar panels. So I'm going to get into those interesting stories here in just a minute. But before we do that, this is an example of some of the more recent solar panels that are coming out. Here are some other designs that are starting to come out, and these are solar shingles. Some of you have heard these on the news. I know Elon Musk is making a big push for these, but eventually they're going to become something that's not as noticeable, which I think will change the dynamics of what an association needs to do for the shingles. So these are examples of the newest and latest and greatest solar shingles. Nationwide, I want to let you all know this is not a local problem for us here in the Carolinas. This is a national issue. And so the courts and the legislatures have taken two different approaches. Number one is what I call solar easement laws, okay? So 14 states have statutes or laws that protect your right to get the sunlight. Okay, so if I want solar panels, but my neighbor has a bunch of trees, I might have an easement to get that lighting. Okay, now that's not North Carolina or South Carolina, but it is one way that North Carolina and South Carolina could address this. Okay, so that's something to keep in mind going forward, and we're going to talk more about that here in a minute. The other way is solar rights law. Okay, solar rights law, and that is I have the right to have solar panels in some way. Okay, and it creates a right or an opportunity for an owner to install solar panels. Now, North Carolina is in this list, and I'm going to go over that statute here in a few minutes. South Carolina is not, because South Carolina is one of those 10 states remaining that really has no guidance on solar panels yet. Okay, so that's where we are. Kind of snapshot picture in the Carolinas is that North Carolina does have some law, and South Carolina doesn't have law yet, as kind of an overarching issue. The current North Carolina solar law. Okay, so if you're a North Carolina association, this is our law. It's North Carolina General Statute 22B-20, and here's the way it works. It was enacted on October 1st of 2007. Okay, so big point here. If you're an association that was created prior to October 1, 2007, this does not apply to you. Okay, you still have just regular architectural control. You can turn down solar applications. Okay, but after October 1, 2007, if your association was created after October 1 of 2007, then the North Carolina statute does apply to single family homes, the ones, that have your own lots, the townhomes that was amended in 2009 to apply to townhomes, and non-stacked condominiums. So the condominiums are kind of side by side. That statute applies to them as of still of 2007, but it was amended in 2009 to be retroactive. So what does that mean? That means that in North Carolina, if you are a single family home, if you're a townhome, or if you're a condominium created after October 1, 2007, then you've got to follow the statute on whether people are allowed to have solar panels or not. If you're created before October 1, 2007, it's just regular old architectural control. Do you want it? Do you not want it? Aesthetics, just like you would a shed or a paint color change if you were created before October 1, 2007. The key to this is if you were created after October 1, 2007, then you can't outright prohibit solar installation anywhere on the lot. Okay, that's that right to have it, or the opportunity to have it. The homeowner is going to get solar panels somewhere on their property if they were created, if the association was created after October 1, 2007. And again, if it was prior to October 1, 2007, it's regular architectural control rules apply. All right, now, those created after October 1, 2007, here's the law, okay? Here's what you have to allow or not allow. You cannot allow solar panels on the facade of the structure or the outside of the structure that faces areas open to common or public access. Okay, and that's a real fuzzy phrase, as you're going to see here in a minute. But we can say no, you can't have those solar panels on the house. Okay, here's our sample house. This is the exterior facade. You can't have a solar panel on the front door. You can't have a solar panel there in between the windows. This is the exterior facade facing the open areas, the areas of open to the common and public access. You can't have it there either. And we're presuming we're standing on the street, obviously. Can't have it here. Now, so that's the one, the facade of a structure that faces areas open to common or public access, we can deny, okay? Next, we can also deny on the roof surface that slopes downward toward the same areas open to common or public access that the facade of the structure faces. What that means is, okay, here are the original X's we talked about. Also can't have them here on the roof because it faces the open, the areas open to common areas and public access. Not here, not here, not here, not here, okay? So that's the roof issue. We can deny solar panels on the roof if they are areas open to common or public access, roads primarily, okay? The last one is you can deny solar panels within the area set off by a line running across the facade of the structure, extending to the property boundaries on either side of the facade for those areas of common and public access faced by the structure. What does that mean? The front yard, okay? From the front building line of the house to the road, we can prohibit solar panels, okay? So we can prohibit them here and here and here and here, okay? The front yard and there. Now, when you start looking at the rear of the property, we still have some authority for the rear of the property, okay? But you cannot outright prohibit solar installation in the rear, in the places that they are permitted. And in North Carolina, and again, these are North Carolina statutes for single-family homes, townhomes, and side-by-side condos. But you can regulate the location and require screening of the solar panels on the back part of the house or in the backyard, so long as it does not, quote, have the effect of preventing reasonable use of a solar collector for a residential property. In other words, you have to be reasonable. Okay, you can't require such screening or trees or fencing to screen it from view from in the backyard to the point where the solar collectors don't work. It blocks the sun, or it blocks the sun 10% of the day or 20% of the day. Okay. What we have found is that when you try to regulate the solar panels in the back of the house, it gets real tough to justify those kind of location and screening requirements. So absolutely talk to your lawyer about that if you're going to try to prevent solar panels at the rear of the property, because the law is not very settled and it's all about reasonableness, which we all know that's a tough standard to pin down if you can. Now, interesting, townhomes, side-by-side condominiums, and other associations where the association is responsible to maintain the roof or the exterior surface or the backyard or the places that people want to put solar panels. What do we do if the association is responsible to maintain those areas? Okay, well, the statute was good enough to give us a little bit of guidance on it that says your declaration can make the owner responsible for all damage caused by the installation, existence, and removal of solar collectors. Okay, also the title owner of the residence can be held the title owner of the residence shall hold the association harmless and indemnify the association for any damage caused by the installation, existence, or removal of solar panels. Okay, and the homeowners association shall not be responsible for the maintenance, repair, replacement, or removal of solar collectors unless expressly agreed in writing. What does all of that mean together? That basically means that your declaration can say, look, if you put solar panels on something that we're responsible to maintain, then we can build into our declaration, you're going to indemnify us, you're going to hold us harmless, you're going to be responsible for any damages that occur, and you're responsible for any interior damage. Let's say they drill a hole in the roof, put a solar panel up there, and now the roof leaks. Well, if you have the right language in your restrictive covenants, then you could put that on the owner. Okay, so those are for townhomes and side-by-side condos for the most part. All right, true or false? If a neighbor A can view through an upstairs window the solar panels proposed to be installed on the roof of neighbor B's home, then the HOA should deny the proposed installation. So basically, if one neighbor can see the other neighbor's solar panels that they intend to put on, can they be denied installation? And the answer is false. Okay, here's why. Those are just neighbor to neighbor, and they don't even have to be next door to each other. I mean, it could be a neighbor 3 doors down or across in a different cul-de-sac that can see over the trees. I mean, it can be, any neighbor. Why? Because that is not areas open to common or public access. Okay, that's just a neighbor looking at another neighbor's house. That's not areas open to common or public access. So kind of remember that phrase. That's important. All right, here's a good example. You can see the house up in the upper left-hand corner. That house has solar panels, actually solar shingles, the new ones. Where am I standing when I took this picture? I'm standing on common area, okay? Now, this gets really slippery, okay? The statute says that we can prevent solar panels in areas open to common or public access, okay? It is our opinion that does not necessarily mean common area. In other words, I can see these solar shingles from the common area, clearly. Does that mean that we can prevent them? Our position is no. Our opinion has had to be no, because that does not qualify as an area open to common or public access, because the general population doesn't come to our common area necessarily. So, and I think that's what the intent of the statute was, is to prevent the public from seeing it, not necessarily other members of the association who are on common area or in their houses. So that gets a little slippery. The other interesting point that I wanted to raise is, let's say that you could see this house. We'll just use this house as an example. Let's say that it was a little bit down in a gully, okay? And I could see these shingles on the back of the house, from 2 cul-de-sacs over, standing in the street. Okay, so I am in an area open to common and public access, but I'm 2 cul-de-sacs over, kind of up on a hill, and I can look over and see those solar collectors. Does that mean that we can restrict them? I don't think so. I mean, I think a court would look at you and go, "You got to be kidding me." Okay, we think the intent really is, if you're driving down the street and you pass this house, can you see the solar collectors on the roof? Okay, so again, this is all very kind of unsettled law, but so talk to your lawyers about it. But that's kind of the flavor that we've got for it. Now, here's the fun stuff. There is actually a case in North Carolina that is going to the Supreme Court of North Carolina about solar collectors. Now, in a strange and I guess geeky way, lawyers like us in the community association world are anxious to have this heard. I mean, this is the guidance that we're looking for. We want more guidance on what this statute means. So let me tell you the story. Belmont versus Farwig. Okay, this is a Court of Appeals case currently from 2021 that is being appealed to the Supreme Court. And here's what happened. The homeowner installed solar collectors on the roof, sloping down toward the public road. Okay, clearly an area open to common and public access without approval. Okay, so they put the solar panels on the front roof without asking. They later submitted a couple of architectural applications, and all of them were denied. The homeowner sued, and the association won at summary judgment. Now, that was at the trial court. You know, when you try cases at the trial court level, there's a step called summary judgment, which is very early in the case, where you say, okay, judge, you know, our facts are so strong that we should just win and not go any further. And so the judge found that the association was right and granted summary judgment for the association to win. That no, you can't have those solar panels because they're on the front of the house, and that is an area open to common or public access. So now the homeowner appealed. Okay, the next step is the Court of Appeals. So at the Court of Appeals, the homeowner's arguments are these, and this is what happens when you have a new statute. Okay, the homeowner argued that not allowing solar collectors on the roof effectively prohibits reasonable use of solar collectors in violation of the statute. In other words, if my house only faces this direction, and the only way I can get good solar is if my solar panels are on the front of my roof, then by preventing me from having solar panels on the front of my roof, you're preventing me from having reasonable use of solar collectors. And you're not allowed to prevent the reasonable use of solar collectors under the statute. So that's one argument. The second argument is that the declaration was silent on solar collectors. So the installation of solar collectors were not a violation of the declaration. And this gets a little bit involved, but what the argument was is the declaration was silent on solar panels collectors. It didn't say you can't have them, couldn't have them, where they would be. The association was relying only on the statute. Okay. And the homeowner's argument was, Judge, there's no rules in the declaration. There's no restrictions in the declaration. The association shouldn't be allowed to just rely on the statute. So, Judge, rule for us. Okay, we should win. Things should be expressly set forth in the declaration of the association about solar collectors. And if it's not, the association should lose. That's their second argument. Now, the Court of Appeals found for the homeowners association. So the Court of Appeals did not buy those two arguments of the homeowner. Okay, the homeowners have appealed to the North Carolina Supreme Court. I assume they're going to make those same arguments in addition to other arguments, and we're waiting to see what happens with that, because it will certainly decide a lot for us. So I'm asking you all, just mentally, what do you think the Supreme Court will do with this? Okay, one, do you think they will rule for the homeowner because the homeowner cannot get enough power without solar collectors on the roof facing the street? Okay, do you think the Supreme Court, after hearing the arguments and that the homeowner is going to lay out, and having seen the statute I've showed you, you think that the court will rule for the homeowner because the homeowner can't get enough power with solar collectors, which basically renders their property unable to get solar power? Or do you think that the Supreme Court's going to rule for the association and prevent solar collectors on the front slope facing the road because of the express restriction, does not have the association's governing documents, and the association can rely on the statute alone? In other words, do we think that the court's going to rule it's okay if your declarations are silent? The statute is strong enough to allow a homeowners association to prevent solar panels on the front roof. Ben, do you have a question come up?
Well, I was going to launch the poll, so hopefully,
let's do it.
It should work.
Oh, excellent. Okay, so these are the two questions. And for those of you who are looking at this later, what do you think the Supreme Court's going to do? Rule for the homeowner because the homeowner cannot get solar power, or rule for the association because the declarations were silent and the statute is strong enough? Oh, this is good. I'm sorry, I can see the results coming in, so I'll tell you what they are in just a second. See how we're doing. All right, looks like, yep, everybody has answered. All right, well, the results are that 35% of you believe that the homeowner will win, okay, because they should be able to get solar power, regardless of the statute. 65% said that the court will likely rule that the association can prevent it relying on the statute. So that's very interesting. We'll see what happens. That's the fun part about this, is we don't know. We'll see.
Hey, Steve, we did have one question that came in. Well, I guess we might wait for this if you're talking about charging stations later. So I'll hold off on that question.
That's fine. Yep, I am going to talk about charging stations here in a second. Good. Thanks for that poll, Ben. All right. Different case. Okay. Now, this case is only at the trial level. Okay. It has not gone to the Court of Appeals. It's a long way from the Supreme Court if it's ever going to be appealed at all. But there's a current case for one of our clients that is interesting. And this is kind of the way, this is really for an example of how passionate people are about getting their solar power. Okay. Facts are, homeowner requested approval of solar collectors multiple times and was denied every time. The homeowner canvassed the community to seek signatures for an amendment. They went out and tried to pass their own amendment to allow solar collectors. I mean, very creative, approach. The homeowner believed they had the number necessary to amend the declaration to allow the solar panels. So the homeowner actually went out and recorded an amendment themselves to the declaration. Now, we're having a disagreement as to whether or not that's a valid amendment to the declaration for a couple of different reasons. And the association has filed a notice with the Register of Deeds that says we're rejecting this amendment because of some issues out there. So sorry, I can't give you more details on that one, but that's kind of where that case stands as of today. It's too early in the litigation to forecast an outcome. But again, that's not so much about substantive solar collection law as it is homeowners want this stuff, and they want it the way they need it to get as much power as they can. And they're willing to go to great lengths to get it. So board members who are sitting out there tonight, be aware of that. This is, in my opinion, this is not you denied my shed, you denied my gazebo, you denied my fence. I think there's another level of kind of emotion and passion behind these solar collectors. So be ready for that. We're going to talk a little bit more about that in a minute. Now, proposed legislation in North Carolina. I've gone through the statute with you, the one that says, we can regulate them on the front of the houses and in the front yard and the front roof and all. I've walked you through all of that, but there's some additional proposed legislation that's been kind of floating around out there. We don't think any of this is going to get traction. We don't think it's going to become the law, but it could. Multiple proposals come out pretty much every legislative session. One of them was to eliminate the HOA's ability to deny solar collectors at all. I mean, the homeowners could just do it. Front facade, front yard, front roof, didn't matter. Okay, so that law was proposed in 2019, didn't go anywhere, but it could come back. Other proposals would require the HOA to allow installation if the HOA's rule reduced the operating efficiency of the proposed collector. Okay, it's a 10% reduction rule. And here's what that is. And California follows this, I believe, still. Homeowners should be allowed to put their solar panels somewhere where they can get at least 90% efficiency. That's the kind of idea. And that means that if it's on the front, it's on the front. If it's in the front yard by the mailbox, by the road, then maybe that's where it has to be. Okay, so that's what I was saying here. So if someone can prove that, hey, if I can just put it on the back roof, I'm going to reduce my efficiency by 22%. Okay, so I need it other places. I need it in the front roofs. I need it on the side. I need it on big stands, facing the sun in my front yard. A 10% reduction rule may allow them to do that. It would just be a matter of somebody proving that they lose more than 10% by being prohibited to put them certain places. So all of this is kind of on the back burner legislatively in North Carolina. So I don't want you to spend too much time thinking about it, but just know, I think the future is coming. And I think that the law is going to change. And these are just some of the ideas that are out there on changes that could take place. Yeah, and obviously, in the end, they could be as bad as homeowners association cannot prohibit installation. That is a possibility. All right, moving on. South Carolina law. There isn't any South Carolina law currently. So everything we've been talking about is North Carolina. And don't forget, just single family, townhomes, and side-by-side condominiums. Okay. Let me take a second here to just talk about condominiums in North Carolina. The law doesn't apply to them. Stacked condominiums doesn't apply to them, for the main reason that all of the areas that someone would want to put a solar collector is common elements. It's not their unit. And so they don't really have the right to put things there. And so I think that's why the legislature didn't make it apply to stacked units. So right now, the point being, in North Carolina, the association does have the authority to deny solar collectors anywhere on a condominium, stacked units, on the roof, outside, parking lot, all of that. The association would still have the discretion and the ability to deny solar panels in North Carolina. Now, South Carolina, again, no law. However, there was a bill that started up in 2021. Several South Carolina senators got together and said, we want a solar collector law for homes. The Legislative Action Committee, the CAI, Community Association Institute, LAC, Legislative Action Committee, got together and was asked, and actually David Wilson is one of the lawyers in our office, in our Charlotte office, who serves on the Legislative Action Committee. So I kind of had a front row seat to what he was doing and helping with this. The senators said, here's our idea of what we think will pass as a law in South Carolina, gave it to the Legislative Action Committee, which David is on, and they tried to tweak the language to make it something that associations could live with going forward. And so we were actually involved in drafting the bill. I was standing behind David as he's typing what could become South Carolina law. The bill language is difficult to draft, as you can imagine, because you're balancing the interest of a lot of people. Builders, how do they feel about solar collectors? Homeowners, well, we know some of them are very passionate about solar collectors, and some of them are adamantly opposed to looking at solar collectors. Solar companies, they're getting to be a big lobby group, solar companies. So I think they've got some what they call juice when it comes to legislation. Associations, power companies, there's a lot of different groups that have an interest in this. And so the bill is hard to draft to make all of those people somewhat happy to where the bill can move forward. So that bill has stalled out at this point. So we do not expect a South Carolina law to come anytime soon. Speaking of which, a new North Carolina law would be passed almost exactly the same way. A senator or a House representative would propose a bill. It'd go to people would be involved in its drafting and drafting it to try to please a bunch of different groups of people. And then if it can, it goes through and it gets passed into a law. But right now, that's not happening in South Carolina for now. All right, what do you need to do? You're a board of director. You need to be prepared for the solar collector issues. I pointed out a lot of the stuff that's out there that's coming, and you need to be prepared. What we have learned in experience is being on your heels and having to handle solar collector issues just as they come makes them much, much more difficult and much more expensive from the legal side. Okay. In other words, if you have never dealt with a solar collector issue, you have no policy, you have no guidelines as to how you want to deal with them, then when they come, you're basically working with the lawyer to figure out how to do it, which is a lot more expensive than trying to do it ahead of time. So the point is, create a solar policy. Okay, solar collector policy. This can be a policy just like any other policy. The board of directors can do it. You don't need the membership involved in it. You're welcome to get their feedback if you want, but the board of directors gets to decide what the solar collector policy is going to be for the association. In doing that, you need to know what the law is. What's the law require? I've given you a very high 30,000 foot level view of what the law is in North Carolina. So go talk to your attorney. Okay, let them help you with the policy. As part of that policy drafting, do you want to allow solar collectors? Okay, and how much do you want to allow solar collectors? And if you do, where do you want to permit it? What other requirements do you want to include in your policy? What should they look like? What colors, design? How about the wires and conduits? These things have to be powered somehow or send the power down somehow. So can the wires be on the side of the house? Or do we need them to be painted the same color as the house? So lots and lots of issues. But if you can create the policy early, it will save you a tremendous amount of time. And with the value of most policies, if you can produce it, vote on it, adopt it as an association policy, and share it with the membership, that gives your membership some guidance on, okay, if I want solar collectors, I can hand this policy to my solar company and say, we have to follow these. And it makes it much, much smoother on both sides and really reduces the chance of getting into a fight with a homeowner once they've already done something they should have done. In other words, be proactive. Get a policy together. Yes, it's probably going to cost you some money to do it, but it will cost you far less to have a policy put in place and following that and fending off these cases that are coming. All right, Ben, next question. How many years do you believe it will take for laws to be passed further protecting owners' rights to solar collectors on their private lots? Okay, now not condominiums. I'm just talking about single-family homes and townhomes. How many years do you think it will take for laws to pass further protecting owners' rights to solar collectors? Choices are 1 to 2 years, 3 to 4 years, 4 to 5 years, and more than 5 years. So we got the results coming in. Very interesting. Good. All right. The results were these: 1 to 2 years, 23%, 3 to 4 years, 59%, 4 to 5 years, 9%, and more than 5 years, 9%. Now, what this tells, and this is exactly what I was looking for, is 3 to 4 years is pretty quick for the law to change. Okay. The bill process, I just mentioned how that works. But I think you're right. I think it's such a hot issue. I think there's already bills being proposed. I think that it's going to have to be addressed. So let's do the next ones. The next question. How many years do you believe it will take for laws to be passed further protecting owners' rights to have solar collectors in condominium common areas? Okay, so let's launch that one, Ben. And the difference is, remember, the difference is the owners don't own the land. The owners don't own the land in a condominium. You're talking about putting it on common elements. How long do we think it'll take for the legislature to allow solar collectors on common elements? Same options: 1 to 2 years, 3 to 4 years, 4 to 5 years, or more than 5 years. Yeah, good. The results were these: 0 thought 1 to 2 years. I think you're right. 0 thought 3 to 4 years. I think you're probably right. 18% said 4 to 5 years. I think that's much more in line with what will happen. 82% of you said more than 5 years. And if I had to put some money out there, I would say it's more than 5 years, just because the rights, you're basically putting Steve's solar collector on the land that's partially owned by 89 other homeowners in a condominium. Okay, because everybody owns the common elements. So I think that's got some legal hurdles to it, but good, very interesting. All right, next. leaving solar panels. Ben, you have questions for solar panels?
Well, Steve, yep, a couple of questions for solar panels. Are there any federal laws that would give guidance on solar panels or yeah?
Yeah, great question. Great question. Currently, there are not federal laws regarding solar panels that are relevant to HOAs or condos.
Okay, and how about with tax credits as a nonprofit corporation? Do associations get tax credits if they want to put solar panels on common grounds or any amenities?
Wow. I'll tell you what, I'm going to have to punt that question simply because it's a tax question and I'm not a tax lawyer. I don't know. I don't know the answer. And whether or not the real question is, are tax benefits and tax rebates only available to individuals or to corporations and nonprofit corporations? If I had to guess, I would say they're available to anybody. Would be my guess.
I guess I could ask a follow-up question to that one. If an association wanted to put solar panels on common property to run their clubhouse or supply solar energy elsewhere, could they do that?
Yes. The association has the authority to do whatever's reasonable with our common area. In other words, if you want to build a tennis court and it's reasonable, build a tennis court. If you want to take away a tennis court that's already there and it's reasonable, you probably have the right to remove a tennis court. So could you put solar collectors on common area? I think if it's a reasonable, good business decision, yes.
And then I guess last question, well, maybe a few more coming in. Anything gained or lost by not allowing solar panels? And that would be more maybe aesthetic.
Yeah, it's pure, well, generally speaking, which is what I have to do here, generally speaking, I would say that the decision on what you do with solar collectors is purely aesthetic. What does it look like? We don't get into the issues of people, basically being environmentally responsible, a homeowner being environmentally responsible. I don't think that's a safe place for us to be. It's purely what does it look like? So when you get into should they be involved or how involved should an association be or how strict should an association be, that really is just a pure question of aesthetics.
So I'll say the last question, but on solar panels, if a townhome community or even a single family community allows solar panels, is the association responsible to cut trees to allow them the highest efficiency possible from a common area or other property?
Right. I would answer no to that. That goes to when we showed the slides earlier about some states go with easement rights. Sunlight, you have an easement right to the sun. That if we had that in North Carolina or South Carolina, then the argument would be possibly, yeah, we might have to cut some trees or top some trees to get that easement right honored. We don't have that in North Carolina or South Carolina. We are more of the homeowner can have the right to have them, but we don't have a duty to give them as much sun as possible.
Okay, charging stations.
Charging stations. Electric vehicles. This is pretty interesting stuff. In 2019, 1 out of 40 new cars were electric. By 2029, 1 in 5 will be electric. So my point is that's not very long from now. Associations need to be thinking about this pretty quickly on how we're going to deal with electric vehicles and charging stations. The initial question is, do we have to approve charging stations? The answer is no. There is no state or federal law that requires us to approve charging stations. Okay, now that doesn't mean a law couldn't be passed, and we talked about how that works. Similar to the North Carolina solar collector law, it's possible that North Carolina and South Carolina could say, okay, associations can't restrict charging stations in these locations, kind of like they did with solar collectors. Okay, you can't prohibit them completely. You can just restrict some of the areas they can be in. Very possible, and that's probably where the state laws will go. Now, no, there's no federal mandate now to allow charging stations, but it's possible. For those of you who have had any experience with HOAs for any amount of time, you know that the feds stepped in with the over-the-air reception device federal FCC regulation, affectionately called OTARD, that says you can't unreasonably interfere with people's signals from outer space to their satellite dishes. Okay, so that's just an example of the feds stepping in and saying, we don't care what your association documents say. We're the feds. You know, we're protecting satellite dishes. The feds could easily come in and say the same thing. We're protecting EV charging stations. So very possible. Are all of these going to happen, state and federal? Probably. I didn't do a poll for this one, but it'd be interesting to know. If I had to guess, I would think that state laws are within the next 3 to 6 years, I would think. The feds probably longer. The feds kind of try to stay out of state and private issues, but possible, very possible. All right, so let's say that we want to consider charging stations. What are the considerations? Do we do individual charging stations with individual approval? I'm in a townhome. I'd like to have it out there in the common area in front of my house. Okay. It could be building by building. Let's say the last few parking spaces down on the right are charging stations and are allowed to have charging stations, and you got to park down there if you want to have a charger. Centralized charging locations. Okay. If you're like in a quad type setup, is there something in the middle? Maybe. Are we talking about basic 110 volting charge, which last I read takes 8 to 12 hours to charge a car, or a superchargers, which can take several hours to charge a car? What do we want to do? Who's going to pay the power bill? That's going to become a question that needs to be dealt with. And does this create assigned parking requirements? Because if you put a charging station at the end of the building and there's 2 charging stations there, and I park my regular gas-powered Honda there, is that okay? Or is it actually an assigned parking space for somebody? So these are going to become issues that we need to look at with charging stations. Can the association make money off of charging stations? That is a big question. And I just threw it in here because I wanted to plant this in your head, is you got to be careful in selling power or selling water. That could turn you into a utility, which makes all sorts of regulations come down. So if you're thinking about putting in charging stations by the association to be billed from the association to a homeowner somehow, we need to really talk about that, or talk to your lawyer about that. That could have some unintended problems. Liability considerations for charging stations. And let me be clear. I'm talking really about 2 different types of charging stations. One is outside of somebody's townhome. I live in a townhome. I'd like to put it, right there next to my driveway. It's on common area, but it's only for me. It's in my driveway. I'll pay for it. I'll meter it. It'll be mine. That's one type of charging station. The other is some charging station that is common, and the association is doing it to be common, and the issues that arise there. But either way, if the charging station is in common area, you're going to have to figure out the power source, the wiring, the metering, the nozzle, who's responsible for each segment. If the wire runs from the charging station across common area and then onto somebody's lot to be hooked into a meter somehow, there's some legal kind of real estate issues that have to be figured out. An indemnification agreement. What that means is, I'd like to have a charging station outside of my townhome, next to my driveway, just for me. Okay, let's say we approve that. Homeowner, Steve, go ahead, build it, pay for it, meter it yourself, pay your power bill. That's fine with us. Well, it's on common area. That's a big piece to this. It is on common area. What if it bursts into flames and burns the building down, or bursts into flames and hurts somebody, or electrocutes somebody? It's on common area. Okay, so there are some indemnification. Do we have to have people sign an agreement that says, I waive my rights, I release any kind of claims, I'll protect the association if my meter or if my charging station blows up and hurts somebody? Lots of legal issues there. Liability insurance, of course, the answer is yes, and lots of it. I suspect your insurance agent probably has already crossed this bridge and has some kind of riders that would cover this kind of thing. Talk to your insurance agent about that, but the answer is yes. Theft. If you've got these charging stations, pieces get stolen. Do you actually insure the equipment itself against theft, like property damage, vandalism? Those kinds of issues have come up in these issues. Now, what if I wanted it for my townhouse and then I move? It's on common area next to my driveway in my townhouse on common area, and I move away. Next owner comes in and says, I don't have this and I don't really want this here. Who's going to pay to remove it? Okay, who's responsible for that? Now, before I go there, you'll notice that these last few slides for EV charging stations are a lot of questions, okay? That's because there aren't any great answers right now. The big piece I would tell you about for EV charging stations is, one, if you're going to put it, if someone wants it on their private property and it's just an ARC issue, architectural control, then be reasonable. I mean, this is coming, okay? So you need to be reasonable in your ARC approvals. If it's on common area or limited common area, that's when a lot of these questions come up. And I would ask you to talk to your lawyer, get your lawyer involved to cover yourself as much as possible. Ben, we got a question?
So a couple of questions. One, I guess, does the association have any responsibility to provide a charging station or access to install a charging station if it is across common property?
There is no obligation on the law. There's no state or federal mandate that you have to give someone let someone have a charging station, okay, from the law side. Then the next analysis down is the good business judgment decision. Is it a good business judgment decision of the board of directors to allow this or disallow it, okay? And that can be very fact specific, okay? And you'd want to talk to your lawyer about that. But the point is, it's the board's call. And if they can justify allowing it, that's probably okay. If they can justify disallowing it, that might be okay too. But a very fact-specific question.
Okay, so have you seen charging stations? And I'll say we may not have seen a lot of charging stations, but have charging stations influence the price in the sale of buildings, condos, townhomes?
That's an interesting question. I have not. I mean, we do thousands of real estate closings in this firm every year. I have not heard that come up of, oh, I'm buying this because there's a charging station next door or in the driveway. I haven't heard that, surprisingly.
But I'll tell you, I've been involved with charging stations and I've experienced every single one of these issues when it comes to liability considerations. And so quite complicated, from tripping hazards across common property to installation of meters to removal. So it's very interesting.
It is. It's the new world. So be ready for it. Start talking about it. You can do a policy for it. I mean, if you're that ahead of the curve, you can start talking about getting a policy so that when the request comes in, you're ready. You've got steps to follow and standards already in place. That's a great idea. All right, any other EV questions, Ben?
No questions right now.
Okay. Lastly, clotheslines. Clotheslines. Most covenants prohibit clotheslines. Now, states can do different things. Florida and Utah have a right to dry statute, believe it or not, that you have the right to have a clothesline under certain conditions. Retractable clotheslines may circumvent the covenant. So let's say it says you can't have a clothesline. Well, what if it's retractable? What if it's only out when I need it? Those are kind of some of the legal gymnastics we get to do sometimes. And can you screen clotheslines or allow them on certain hours and certain days? Here's the point. There is no state, North Carolina or South Carolina, protection for clotheslines. So you can prohibit clotheslines, and there's no federal protection for clotheslines. It's going to come through the state at some point, I suspect, maybe. But it's not there yet. So if you have a restriction that says you can't have clotheslines, then that is an enforceable restriction, okay? If you have someone apply for a clothesline, they want to put one in and they submit an architectural application, you can deny it, okay? Because there's no protection, state or federal, for clotheslines at this point. So, all right, that is in a nutshell, green initiatives for HOAs and condominiums. Ben, do we have any other questions outstanding?
Well, I'll ask one question. It's unrelated to the three areas of green initiatives, but drones. I know there's federal laws around drones, but we're starting to see more and more drones in HOAs doing different things. So are there any suggestions, ideas, thoughts about limiting drone usage on common property?
The association, all associations can create reasonable rules and regulations about their common area, whether it's what time the pool opens or closes, but you can create rules and regulations about drone usage. The board of directors can do that with no membership involvement if you want to try to do that. Are drones protected somehow? No. No, there's no protection. So if you want to say no drones on the common area, that is an enforceable rule in the association, and you can enforce that rule. Now, as far as drones flying over people's private property, very hot issue, amazingly. And without a restriction in our declaration that says you can't fly a drone, off of your own property, then that's really kind of a neighbor to neighbor issue. Could you argue it's a nuisance? Maybe. Could you argue it's an annoyance? Maybe. I think you would probably lose if it really went very far. But yeah, common area, we have all the control over drones we want. Drone conduct on private property, much, much tougher.
Rain barrels is another item that we occasionally see in associations. Are there any restrictions around rain barrels other than what would be in an architectural?
Yeah. Rain barrels are not protected by state or federal law. So we can treat rain barrels just like we can a shed or a fence or a ARC issue.
Okay. Well, that ends the questions. I guess if there are no other questions that have come in, I'll say thank you, Steve, for your time this evening.
Thank you all.
Great information. I know we are going to continue to see these issues pop up from time to time. I know there's a lot of discussion around electric charging stations. So I've been involved with several. So again, thank you. We will sign off and hope to see y'all next time.
Thank you all.
Thank you. Bye-bye.